Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so this is a Sean Combs update in regards to his criminal case. The judge has ruled in regards to the BOP investigation where the BOP investigator took the pictures of his notes, and there was like a big debacle, and pretty much Sean Combs was requesting for an evidentiary hearing for the judge to actually make a ruling in regards to the BOP investigator. The last that we spoke, a I believe um the attorney for the Southern District of New York, one that was on the prosecution team or in relation to them, as well as the BOP investigators, submitted their declarations to the court, pretty much giving us an update or giving the court an update, whether or the judge, um, trying to tell them the steps in which they played in the MDC sweep. So Mark Agnafilio and Diddy have been pushing, trying to pretty much get this case one dismissed, but just trying to say that hey, the government is not playing fair. They're not playing fair. They're not doing what they're supposed to do, and somebody needs to be doing something to it. But I think in this opinion and order, they're about to get a serious wake up call. So let's hop right on into it. All right, so this is Judge Iran Romanian's order and opinion and order in regards to that MD sweep, specifically to the BOP investigator. It reads, in connection with the Bureau of Prisons October 28, 2024 to November 1st, 2024 sweep of the Metropolitan Detention Center, a BOP investigator, Investigator 1, photographed 19 pages of Combs' notes and sent them to the government's filter team. The filter team consists of the AUSAs who aren't involved in the investigation or prosecution of this case. The filter team redacted the notes and sent them to the case team. The case team consists of agents and AUSAs investigating and prosecuting Combs. So that was the biggest thing, because what they were trying to say is the government used those 19 pages in their motion to oppose the motion for bail. And so the defense pretty much feels like the information that they obtained was used against them. And so now the judge has to determine whether that was the case. In November, the government included some of what is received from the filter team in its opposition to Combs' bail application, and Combs objected, arguing that those notes contained privileged information and were obtained in violation of Combs' constitutional rights. The court held an emergency hearing in which the government indicated that it would not rely on the notes in opposing the bail application. The court ordered that the case team to get rid of the notes in its possession, which it did. Combs has now filed a motion for an evidentiary hearing and other relief, arguing that the seizure of the notes violated the Fourth Amendment and that the government intentionally obtained his privileged communications in violation of the Sixth Amendment. In response to the motion, the government argues that there were no violations, but also that it won't offer as evidence the notes or any fruits of the notes. In a December 20th, 2024 ex parte letter, in the contents of which were later shared with the defense, the government outlined certain investigative steps taken upon receiving the notes, but it represented that it will not offer the evidence obtained pursuant to these investigative steps in the prosecution of the defendant, and that it intends to produce the evidence obtained from the steps to the defendant to the extent it has not already. In a nutshell, they're saying that pretty much what they obtained from his cell, they're not using that in any way to like input them in their pleadings or any oppositions to whatever Diddy files. It also goes on to say that If he wants a copy, which it would be considered discovery, they will hand that over to them. And then he could clearly see that the filter team did their job. Whatever information uh, did not need to go to the prosecution team, they took the liberty of redacting that information. So the government is following the rules. The filter team is following the rules. What the defense team is trying to do is they're trying to find some little wiggle room to get in so everything could crumble. And that's usually what defense counsels do. They try to find a loopholes. They try to find a loopholes, and once they find a loophole, they're going to work on that until the case gets dismissed. All right, so Combs' Fourth Amendment claim is mute. The first question is whether Investigator 1 violated Combs' Fourth Amendment rights when he searched Combs' cell and photographed the notes. Let's see. The usual remedy for a Fourth Amendment violation is the suppression of evidence. Let's see. All right, here the government agrees not to offer the notes, any fruits of the notes, or any evidence derived from any investigation it undertook based on the notes in this case. Of course, if the government later tries to use the evidence it has promised to exclude, then Combs can reprise his objection. But for the time being, the issue is mute. Um, let's see what else. And if y'all don't know what mute means that it's no longer relevant at this time. But in the event that the government does try to use the evidence that they found in the cell, then Combs can come back and object to that. No remedy is warranted on Combs' Sixth Amendment claim. Relief may be warranted under the Sixth Amendment where the government intentionally seeks to obtain defendants' privileged communications to interfere with the attorney client relationship. So that's the biggest thing. He wants a fair trial, right? And so when you start dibbling and dabbling into privileged communication, that can compromise the whole case. But let's see what they said in regards to this. So they said that there are two questions here. Give me a second. It says, did the government intentionally invade Combs' relationship with his counsel? If so, has Combs been prejudiced? Okay, because he has a right to a fair trial, a speedy trial, and a public trial with an impartial jury. It's kind of hard at this point because everybody know what's going on. But did the government say, hey, we're going to go in and we're going to do this, da 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 da, to ruin the relationship that Combs has with his attorney? And if that is so, has his case been compromised? Let me see. They cited Ginsburg. And out of this, they said to make out a violation of his Sixth Amendment rights, the defendant would need to establish that privileged information was passed to the government or that the government intentionally invaded the attorney-client relationship, resulting prejudice. Under the circumstances here, assuming without concluding that a portion of the unredacted notes was privileged, there are no grounds for relief. So, he don't get no relief on that. Now, the government did not intentionally invade Combs' privileges. Remind you, this is the judge's opinion. There are numerous indications that the government did not intentionally invade Combs' privilege. First, it is undisputed that the photograph notebooks were separate and apart from a manila folder that was clearly marked legal. Investigator 1 didn't search that folder. While Combs initially told the court that the photograph notepads were marked legal as well, the defense retreated from this position when confusion developed over the handwritten legal labels that had been added to the notepads. Second, investigator one sent the photographs he took to the filter team, not the case team, to review for any privileged information. It may be that the filter team's privilege determines where inaccurate, but nothing indicates any intention to intrude on Combs' privileges. Third, the court notes the high level and generic natures of the notes and the fact that case related commentary from Combs was often mixed in with clearly unprivileged information like reminders about a family member's birthday or inspirational mantras. Without the context later furnished by defense counsel's ex parte declaration, which explains how specific notes related to defense strategy, and given the circumstances in which investigator one discovered the notepad separate from Combs's legal folder, there is no basis to infer an intentional intrusion into Combs' privilege. Finally, the government prompted turned the photographs over to Combs, which further weighs against any interference of intentional malfeasance. Malfeasance. This episode illustrates why the filter team should communicate with the defense before giving Combs case related material to the case team. But it does not bear the hallmarks of intentional intrusion or conduct that is manifestly and avowedly corrupt. So, and I don't remember if y'all remember, there was a big debacle. So, when the investigator actually took the pictures, it was from a notepad that wasn't even near the manila folder that was marked attorney client or legal, whatever he had on there. Hmm. So, um, what else the judge says Combs further argues that even beyond the photograph notes, investigator one has been an agent of the case team, feeding jail communications to the prosecutors. Let me see, and informant in the defense camp. The court ordered both the case team and investigator one to furnish sworn affidavits explaining the chain of events surrounding the MDC sweep and order the production of all written uh, communications between the case team and investigator one for an in camera review. A careful review of the documents confirmed that there has been no intentional interference with the Combs attorney client relationships. Affidavits by Christy Slavic, who is a prosecutor on the case team, and investigator one gives consistent narratives. Okay, so I think did I say? Oh yeah, I did say she was an attorney. So she is with the case team. So there was an affidavit by Christy Slavic, who is part of the case team. She's a prosecutor, and then investigator one. Now, fortunately, we could not see Investigator One declaration because he is part of law enforcement, and by law enforcement stuff is confidential. So that's why they redacted this. Let me see. The case team then made requests for information about the communications through the proper channels, including grand jury subpoenas. hmm Let me see where that goes. So there is a footnote. Hmm. Trying to see where that footnote goes. Well, I'm gonna read it because I don't see it. But let's see what that footnote says. Looks interesting. Says the BOP's pretrial detention legal access handbook clearly states of calls to attorneys on the non-attorney phone line. The call will not be confidential. It will be recorded. These recordings can be listened to and shared with others in law enforcement, including the prosecutor in your criminal case. So that's what they're saying. Because remember, Diddy's trying to say that all of his calls are confidential. But here in the book, it says that yes, they are going to be recorded. Yes, the recordings are going to be listened and shared with other law enforcement, including the prosecutor in your criminal case. So it doesn't matter if you with your attorney or you're not. All of the calls that are on the non-attorney phone line are not going to be considered confidential. So if I don't know why an attorney would be calling on a non-attorney line, but if they choose to do so, just know it's going to be recorded. So, oh, look at this. It says inmates seeking attorney-client privilege calls must request an unmonitored telephone call. Hmm. So, Diddy, are you asking for an unmonitored telephone call? Because if not, they listening. All right. The two supervisors at the U.S. Attorney's Office were aware that the BOP planned to search the Combs unit during the security motivated sweep, and they supported searching this unit despite delays in searching other units. Slavik's affidavit indicates that there was no direction from any Southern District of New York, that's the SDNY, personnel that Combs be under special scrutiny during the sweep of his unit. And no one at the U.S. Attorney's Office, including the case team, knew that Investigator 1 was part of the MDC sweep until after it was over. The case team was informed of the Investigator's 1 role following the sweep and promptly asked for the photographed notes to be sent to the filter team. The filter team is the one who redacts the notes. So they did what they were supposed to do. So the case team told the investigator to send it to the filter team so that way it can be filtered and redacted so that way it can go to the prosecutors and the defense. Written communications between the case team and investigator 1, which the court reviewed in camera, tell the same story. Okay, let's see what that story is. Let me go down to the footnote. I didn't even put no footnotes. Aw. Oh, there we go. Says to the extent Combs argued that the supervisor's communication suggested that the inclusion of his unit in the search was an effort to obtain evidence against him, that would go to a potential Fourth Amendment claim. They cited United States versus Cohan, where in that case it says potential Fourth Amendment claim where search was initiated by the prosecution solely to obtain information for a superseding indictment. The record doesn't support such a motive, but in any event, the government has foregone any reliance on what was seized or its fruits, muting the Fourth Amendment issue. Now, as for the Sixth Amendment, the record shows that whatever the justification for the search, efforts were made to protect Combs' privilege, undermining any claim of the intentional interference. Ciao, 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 ciao. All right. Now, lastly, far from an intentional prosecution driven invasion into Combs' relationship with his attorneys, the records show that Investigator 1 was doing his job at the BOP intelligence analyst and followed the established channels for reporting communications that pose safety concerns. The case team was informed of these communications when appropriate and similarly followed the established channels for obtaining information and protecting Combs' privilege. Care was taken to shield Combs' communication with his attorneys from the case team. None of this suggests that Investigator 1 deliberately set out to or was instructed to invade Combs' attorney client relationship and impede his defense. So the judge is saying here that the BOP investigator Gator did everything by the book. And I know some people are not going to agree with that, but whatever their guidelines is, and that because they did cite the BOP, the Bureau of Prisons handbook, he went by the procedures. And the judge seen that he went by the procedures, and based off of what the case team, Miss Christy Slavic submitted, and the BOP investigator submitted, their stories are truthful. They said that the judge says that Combe fails to show prejudice. So even if there was an intentional intrusion into Combs' attorney-client relationship, and there was not, a remedy is appropriate only if Combs is prejudiced by the intrusion. Um, And then in Scrimmer, it says, unless the conduct of the government has been manifestly and avowedly corrupt, a defendant must show prejudice to his case resulting from the intentional invasion of the attorney client privilege. Now, the question is whether the potential intrusions into Combs' privilege have produced, directly or indirectly, any of the evidence to be offered at trial. As discussed above, the government has already stated it won't offer as evidence the notes, any fruits of the notes, or any evidence derived from any investigation it undertook based on the notes. The government also submitted an ex parte letter to the court explaining that the investigators' steps it took, the results of which it will not be used at trial, and it provided the defense with the information in the letter. The court and the defense both now have the necessary information to flag suspect evidence if the government later attempts to use it against Combs at trial. However, at this point in the case, the wholly conjectural connections that let's see, that Combs draws between privileged information and the government case, including general allegations of unconnected to any specific evidence to be presented at trial, are insufficient for finding of prejudice. So, in other words, Combs is saying that they used the notes that they took from his cell against him, but he has no proof that they did. All they are doing is relating what was presented in the opposition to his motion for bail package, but that's not evidence. There's nothing in there that says, okay, well, based on his notes, he said this, and this, if that makes sense. So nowhere in their opposition did they reference the notes or what was on the notes in their opposition. So therefore, they didn't prejudice him. They didn't mess up his trial. They didn't mess up his opportunity to a fair and speedy trial. Not everybody's going to want to hear this, but I mean, if we look at the evidence, if you and go back and watch the videos and that I've done, and you will see not once did they ever reference, okay, well, in notepad paragraph, notepad section 2 paragraph 3b, Combs said this. They never once did that. Who child? Now the judge is saying, look, Combs, you talk about you want a hearing. Look, no hearing is warranted. No hearing is needed to further investigate the government's alleged misconduct. Combs argues that a hearing is required to find out what really happened with Investigator 1 and why, as the court should not just accept the government's say so. As such a hearing, Combs suggests that the court should order the government to produce Investigator One's communications with the prosecutors and take his testimony to fully understand what he was thinking during the search and to answer other questions, including who Investigator One sent the photos to and what exactly the prosecutors knew before requesting copies of the notes. So this goes back to what the affidavit was stating. When Investigator One called the case team told him to submit whatever he got to the filter team. The filter team looked at it, they redacted it, and they sent it back to the case team, aka the prosecution team. I don't know how many times they have said this, but the defense keeps going on and on and on about this, and they've already told you multiple times that the case team told the investigator to send it to the filter team. I don't know if they're getting the case team and the filter team mixed up, but I think they are. The court has already issued an order requiring such evidence and sworn statements to be furnished, and an evidentiary hearing on potential government misconduct is unnecessary when the district courts has sufficient record on which it makes its rulings. In Walters, a hearing was denied where the government provided the district court with a detailed narrative based on internal interviews and a review of internal documents, and the defendant was able to respond to the government's narrative. Because, mind you, the court did ask both the case team prosecutor as well as investigator one to submit their declaration, aka affidavits, to the court, and then also allowed the defense team to respond to those letters. Here, the government provided a lengthy affidavit by a member of the case team based on her review of relevant communications and her conversations with other members of the case team and supervisors from the U.S. Attorney District Office. Investigator 1 also submitted an affidavit. Together, these documents present a clear factual narrative, which Combs then had the opportunity to respond. The court also had the benefit of in camera review of the government's communication with Investigator 1. With such an extensive paper record to rule on, no live hearing is needed. No hearing is needed to test the government's evidence for taint. Combs also argues that an evidentiary hearing is necessary to determine whether any of the government's evidence is derived from the notes. A hearing could uncover the extent to which the case team used the privileged notes to develop leads or uncover new evidence, or whether other information from Investigator 1 led the case team to develop new leads or gather new evidence, Combs claims. This is essentially a request for a Catascar hearing in which the government would be required to demonstrate that the evidence it used to prosecute an individual was derived from legitimate, independent sources. There is no binding Second Circuit authority on the question of whether a Catascar hearing is required when a defendant alleges an intrusion upon the attorney client privilege by the government. In United States versus Torrent. Let me see. Oh, they cited that. Then it states that Combe relies on United States versus Scrimmer, where the Second Circuit remanded for a hearing to determine whether information deprived from or derived from alleged privileged sources was used by the government in violation of the attorney-client privilege to prepare for trial, even though the government didn't use the documents directly as evidence. Regardless of whether a Catascar hearing is an appropriate remedy in cases where attorney client privilege is allegedly intruded upon, a defendant has the burden of showing a factual relationship between the privileged information and the prosecution before they are entitled to a hearing. So, what the court in this particular case, um, that Combs is trying to use, it is pretty much saying that you're going to have to show proof that they use that privileged information before you even think about having a hearing. Um, Let me see. They quoted United States versus Blau and then United States versus Connolly, where it says a defendant who seeks catascar relief must first articulate the purported violation with enough specific specificity to permit the government to respond. Combs doesn't come close to making such a showing, particularly now that the government has disavowed use of the notes or evidence derived from them. An insubstantial and speculative possibility of taint, which is all that Combs can assert at this point, does not trigger catascar. This failure to make the required showing is sufficient to end the inquiry and avoid the necessity of the catascar hearing. So, even if the Second Circuit had firmly recognized the right to a catascar hearing in such cases involving claimed intrusions into current attorney client privilege, Combs is not entitled to one here because he has not made a threshold showing that the government evidence is tainted. The generic nature of the notes makes it unlikely that any improper use of the information has or could be made. They give Combs general thoughts on how to approach certain issues, none of which would come as a surprise. However, if a question arises closer to trial as to the use of the specific, good lord, suspect evidence, and Combs can make a threshold showing that the evidence is tainted, then Combs can bring it up to the court's attention. Until then, the court is cautioned, or the government is cautioned, to be mindful of Combs' privileges and the need to abide by a filtered team process. While there is currently no demonstrated need for a special master, the court recommends that the filter team clearly potentially privilege documents with the defense before turning them over to the case team. As of right now, he is not, I repeat, he is not granting Diddy with a hearing. Some people are going to be like, man, the judge is coming down on Diddy. He's not getting fair. We have to look at the process. It clearly stated in certain cases that it was cited, right? That in order for him to be able to have a hearing, he first has to prove, and that Catascar hearing, he first have to prove that the government used the information against him to pretty much blow up his case or not give him a right to a fair trial. So look at that before y'all make any other opinions about this. But y'all definitely let me know what you think about this in the comments below. I love to hear and see y'all opinions about this. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.